Traditionally, public sector employers, including cities, have provided relatively generous leave benefits. This helps compensate for other perks that generally aren't offered in the public sector. Many organizations offer leave benefits that allow employees to take time off of work for various reasons. Leave benefits, whether paid, unpaid, or partially paid, are generally an agreement between the employer and the employee or the employee's representative. Although most Minnesota agencies retain a traditional set of leave benefits, with vacation and sick leave, some have adopted a paid time off or PTO model often used by the private sector. Whatever approach is taken, the employer must be careful to communicate leave benefits to employees and ensure all applicable state and federal laws have been considered. In general, state and federal laws do not mandate any paid leave benefits. However, once an agency offers a paid leave benefit, there are often laws protecting employees' rights to equal access to that benefit. In other words, if an employer elects to offer some type of paid leave, like vacation or sick time, there are a number of laws to ensure that all employees will receive that benefit without regard to any protected status. In addition, state and federal laws will often dictate that if an agency offers paid leave in any one type of situation, it must do so in another. For example, if an employer offers paid leave for an employee who breaks his or her leg, it would then have to offer it when an employee has complications during pregnancy, requiring her to miss work. An employer's practices with regard to vacation benefits are usually governed by personnel policy or a collective bargaining agreement. Vacation leave provides a number of advantages to an agency. It helps attract and retain qualified employees. Employees who periodically take breaks from their work are likely to be more productive and less likely to suffer from burnout. And employees need time off to attend to their personal affairs, and vacation allows the employee to take that paid time away instead of using work time for the purpose. There are a number of practices common among local government agencies when it comes to vacation benefits. These include vacation is generally earned according to years of service with the agency. There's often a waiting period before a new employee can take vacation. Vacation policies offer a use it or lose it provision by which an employee must keep a vacation balance below a certain threshold. Oftentimes, agencies do not grant paid vacation to part-time employees, and employee requests to take vacation are generally required in advance of the date requested. In general, the agency has the right to require an employee to use paid vacation before unpaid leave to cover an absence. The following are some examples of times when the employer may want to do this. When an employee has not worked sufficient hours for a payroll period to account for his or her work schedule, such as the employee worked 32 instead of a scheduled 40 hours in a week. Second, when an employee asks for a leave of absence for a medical or other personal reason and sick leave is either not applicable or exhausted. And finally, during an FMLA leave that is part of an employer's policy on FMLA and applied consistently. Many Minnesota agencies offer paid sick leave to regular full-time employees. The advantages to the employer are similar to those mentioned with regard to vacation leaves. There are also several common sick leave practices. Sick leave is generally accrued in the same manner for all employees. Sick leave is not usually use it or lose it in the same way as vacation. Some agencies do not pay sick leave at termination or only pay a portion out, and most sick leave policies require the employee to report sick leave as soon as possible after the start of a scheduled workday and usually to the direct supervisor. Many cities require an employee to provide a doctor's statement after a specified number of days of absence, and some organizations require an employee to use paid sick leave before taking an unpaid leave of absence. While the law does not require an employer to allow an employee to supplement workers' compensation payments for lost time with the use of sick leave, it is a common practice in most Minnesota agencies. Some agencies have implemented a leave donation policy. This type of policy is generally used to help an employee who's undergoing a catastrophic illness, either themselves or in their family, and do not have enough paid leave to cover the amount of time off required. The policy allows another employee to donate some of his or her vacation or sick leave hours to the employee who's in need. Some issues that should be covered for a leave donation policy include which employees are eligible to participate as a donor and recipient, limitations on the amount that can be donated, conditions under which the recipient can use the donated leave, whether employees receiving workers' compensation benefits can receive donated leave, and a statement that the policy does not limit or extend the time available under the Family Medical Leave Act. In recent years, many employers, both public and private, have discontinued using separate vacation and sick leave programs in favor of a paid time off or PTO arrangement. Under a PTO plan, employees do not earn separate accruals for vacation and sick leave. Instead, they receive one type of leave, that being PTO, which can be used for any personal absence. The advantage of this program is that employees do not need to justify their leave usage to the same extent they do for sick leave. Therefore, supervisors do not have to ask personal questions about employees' health or that of their children or spouse. As long as the employee follows the associated rules in taking PTO, the use of leave is approved. To offset the increased costs of this type of benefit, PTO is generally accrued at a lower amount than vacation or sick leave combined. For example, if an organization typically grants 10 days of vacation plus 12 days of sick leave per year, a total of 22 days, they might only offer 18 days of PTO. Employees with high sick leave usage may see this program as a net loss in benefits because of this issue. However, employees often welcome the flexibility that a change to PTO brings. State and federal laws provide for and regulate military leave for employees who are called to active military service, whether in the reserves or full-time service. Leave from employment to participate in military duty is addressed in federal law in the Uniformed Services Employment and Reemployment Rights Act, or USERRA. State and federal law requires organizations to grant employees with both paid and unpaid military leave, depending on the circumstances. These laws protect the employee's ability to return to work after a period of military leave, protect the employee's accrual of vacation and sick leave during that leave, protect the employee's right to any seniority-based benefits, including any promotions that an employee would likely have received if he or she had been present, permit but not require an organization to pay an employee the difference between his or her military pay and the organization's wages, and finally protect the employee's right to use paid vacation during a period of military leave if the employee wishes to use it. However, an agency cannot require an employee on military leave to use accrued paid leave. There are also many state and federal laws that require employers to allow employees time off under certain circumstances, such as a serious health condition, parental leave, or jury duty. Let's take a look. In addition to FMLA, Minnesota employers with 21 or more employees must provide up to 12 weeks unpaid leave to a new parent in conjunction with birth or adoption, female parental care, or other related health conditions. To qualify, an employee must have been employed for at least 12 months prior to the leave request and must work an average number of hours to equal at least half the full-time equivalent for employees in that job class. While on parenting leave, the employer can require an employee to use eligible paid leave such as sick, vacation, or disability leave, or leave requested by the Family Medical Leave Act. Minnesota law requires employers to provide reasonable accommodations to an employee for health conditions related to pregnancy or childbirth if the employee so requests. State law also provides that an agency must grant up to a total of 16 hours of leave during any 12-month period to attend school conferences or school-related activities relative to that employee's child. All employers are covered by the school conference and activities leave. Agencies are required to provide a number of additional leaves under state and federal law. Agencies may, but are not required to provide paid leave for an employee to donate blood. An employer must grant paid leave of up to 40 hours to an employee who's seeking to undergo a medical procedure to donate bone marrow. An agency may require a physician's verification to do so. To qualify, an employee must work an average of 20 hours per week. There are no state or federal laws requiring agencies to grant leave due to bereavement or attend funerals. However, many Minnesota agencies do offer paid leave for employees who've lost a loved one to attend a funeral. Generally, these policies allow employees to use sick leave for this purpose and impose a limit of 2 or 3 days. Employees must be given paid leave in order to donate an organ or partial organ. An employee is defined as those working an average of 20 hours a week. The leave may not exceed 40 hours for each donation unless the employer agrees to it. Employers must allow victims and witnesses who are subpoenaed or requested to attend court for the purpose of giving testimony time off from work in order to attend criminal proceedings. All agencies are required to provide employees with time away from work for jury duty. Law also prohibits employers from discharging or otherwise threatening an employee who's called to serve. Requirements for compensating an employee vary depending on what status, exempt or non-exempt under the FLSA, of the employees that's called to jury duty. The FLSA requires employers to compensate exempt employees for time away from work for jury duty. Most employers have policies allowing employees to receive normal compensation while serving on jury duty, but some require the employee to turn over any jury duty compensation, except for expense reimbursement to the agency in return. Minnesota law states no public business shall be transacted on any holiday except for in cases of necessity. Holidays include New Year's, Martin Luther King, President's, Memorial Day, Independence, Labor, Columbus, Veterans Day, Thanksgiving Day, and Christmas Day. An employee who's eligible to vote in an election has the right to be absent from work for that purpose. An employer or other person may not directly or indirectly refuse, abridge, or interfere with this right. For purposes of this law, election means a regularly scheduled state primary or general election. And finally, the Family Medical Leave Act, or FMLA, provides certain employees with up to 12 weeks of unpaid job and benefit protected leave per year. FMLA requires group health benefits be maintained during the leave. The employer is required to continue to pay its portion of health insurance premiums during this time. FMLA is designed to help employees balance their work and family responsibilities by allowing them to take reasonable unpaid leave for certain family and medical reasons. Whether an employee can use this leave is dictated by employee eligibility requirements. Agencies with 50 or more employees are likely to have employees eligible for FMLA protected leave at some point.